what happens if you don't have an estate plan? Let me rephrase that. You don't have your own estate planning documents because everyone has an estate plan. It's just whether is it yours or is it one that the state put in place for you because you didn't create your own estate plan. So your own estate plan, that's having your living documents, your durable powers of attorney, your advance healthcare directive, your will or your trust, whatever it is that the lawyer and you worked out makes the most sense for you. Let's say that you didn't get an estate plan and then you lost capacity, meaning you can't manage your own affairs. You will be subject to a court-ordered guardianship. Let's say you don't create your own estate plan, you don't have a will, or you don't have a way to direct assets after you're gone, you don't have a trust, then what happens? Well, again, the state has a plan for you. In Washington state, the laws of intestacy will take a look at what does your property look like? Are you single? If you're single, then your property will be divided equally among however many children you have. If one of your children's deceased, then it goes down to their children. That's the laws of intestacy. If you're married and you don't have an estate plan, you don't have a will, you don't have a trust, then what happens? Well, the state is going to look and try to characterize your property. And even though we live in Washington state and it's a community property state, some of your assets might be considered separate property. If they're separate property, they're treated different than community. So let's say that you have a later in life marriage, you might have a lot of separate property. Or even let's say you inherited something. That's separate property. What's going to happen to that? Under Washington's laws of intestacy, if you're married, separate property on your death goes 1/2 to your spouse, 1/2 divided among your kids. Community property goes all to the surviving spouse. Now, because there's no will, there's probably not a lot of clarity about what the property character is. So it's not uncommon that there will be litigation because the surviving spouse might say, hey, it's all community property. The surviving children in a later in life marriage or a blended family will say, no, this was all separate property. Therefore, we kids get all 1/2 of all of this property. So there is a good reason for litigation because it's unclear. Whenever you lack clarity, that is an opportunity for litigation. When you hear the word litigation, not only is it full of angst and upset and time spent, but think legal fees because litigation gets expensive. So how can you avoid a bad estate plan? Get an estate plan in place that meets your needs so that you and your family are not relying on the state's default provisions, which is guardianship for incapacity and intestacy if you don't have a will or other way to dispose of your property.